Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-5320. Make the Road New York et al. Versus Kristi Noem, Secretary of the U.S. Department of Homeland Security in her official capacity et al. Appellants. Mr. Ensign for the appellants, Mr. Balakrishnan for the appellants.
Morning.
Good morning. May it please the court, Drew Ensign, Deputy Assistant Attorney General for the United States. I'd like to reserve 3 minutes for rebuttal. The universal relief issued below defies binding precedent multiple times over and should be reversed. For more than 130 years since the Nishimura decision, and recently reiterated by the Supreme Court in Thurisigium in 2020, it has been well established that aliens who have not been lawfully admitted into the country are only entitled to whatever processes the political branches provide and cannot rely on the Due Process Clause to impose additional procedural requirements. As this court again explained in Thurisigium, quote, the due process rights of aliens seeking initial entry are simply whatever the procedures authorized by Congress, end quote. That applies even to aliens who lawfully presented themselves at ports of entry and were paroled into the interior for years pending removal, who are nonetheless, quote, treated for due process purposes as if stopped at the border, end quote. And the Supreme Court has further reiterated that an alien who tries to enter the country illegally is treated as an applicant for admission, end quote, which necessarily means that the Due Process Clause cannot be relied upon to impose additional procedural requirements beyond those provided by statute. Thurisigium thus squarely controls this case, but the district court essentially attempted to evade that binding precedent by limiting it to its facts, essentially holding that it had no application beyond 25 yards of the border and a short period of time there after crossing. But that completely ignores and indeed defies Thurisigium's reiteration of the entry fiction rule, which applies to aliens who have been present in the interior of the United States even for years.
I mean, Thurisigium itself makes a distinction. It says that, and it cites cases that treat entry as different than people who have established domicile in the country, right?
I don't believe so, Your Honor. I acknowledge that it does cite to the Landon case, but I think the Landon case does not draw that line. In fact, I think it draws the line differently in a way that's very instructive and controlling here. What the Supreme Court said in Landon is, this court has long held that an alien seeking initial admission to the United States requests a privilege and has no constitutional rights regarding his application, ... Once an alien gains admission to the country and begins to develop the ties that go with permanent residence, his constitutional status changes accordingly. So if you have a lawful admission into the country, that status change can occur, and you can potentially rely on the Due Process Clause to impose additional procedural requirements. But for those aliens who unlawfully entered this country and have never lawfully been admitted, they cannot rely on the Due Process Clause. And indeed, even if they have been lawfully paroled into the United States but not admitted, they still can't rely on it.
What about Zadvidus v. Davis?
What's that?
What about Zadvidus v. Davis, where the court says once an alien enters the country, the legal circumstance changes, including aliens, whether their presence here is lawful, unlawful, temporary, or permanent?
Sure. Zadvidus addressed a different question. That wasn't invoking the Due Process Clause to resist removal from the United States. That was invoking the Due Process Clause to resist potentially indefinite detention pending removal. Detention raises a fundamentally different question than—
You still have to determine whether due process applies.
It certainly does apply, but the rule of Thurisigium and going all the way back to Nishimura is the Due Process Clause requires only those procedures that have been authorized by Congress and nothing further. Until you've been lawfully admitted into the United States, whatever the procedures provided by Congress are the procedures that are due under the Due Process Clause and nothing further. And so in the Supreme Court in Thurisigium, I think, cites notably to the Nishimura case, to the Kaplan case, to the Mizaya case, and reiterates that rule for all of them. And I think that is the controlling, rule of decision here. And it's not merely that Thurisigium itself was 25 yards of the border. It cites a rule that was far, far broader. And I think the Kaplan case is very instructive on this.
Even if we accept even if we accept your portrayal of how the due process clause works, under that, you're saying that there is at least a due process rights that these people have with respect to whatever Congress has specified, right? That's your framing?
That's correct, Your Honor. But
So under that framing, then even if it's the Mullane test as opposed to the Matthews v. Eldridge due process balancing test, there still has to be adequate notice. And there's cases under Mullane, well, language from Mullane itself, but then there's cases like, I'm forgetting, Memphis Light Gas and Water Division, a Supreme Court case from 84, I believe. And then there's lots of cases from, or 78 is Memphis Light Gas and Water. And then there's lots of cases from our circuit that talks about even under Mullane, the notice has to be sufficient, has to inform you at least of what the procedures are or what you're facing. In Mullane, it was someone whose electric bill was unpaid and their lights were about to be turned off. And the Supreme Court said that the notice was insufficient because it didn't provide information on how to contest your bill. The bill might have been wrong. And that was insufficient. So here the district court found that one of the insufficiencies of the notice is that people don't even know and aren't informed that if they've been here over 2 years, this expedited removal doesn't even apply to them. So even under your construct of how the due process clause works, why isn't that a violation of Mullane?
A couple things, Your Honor. We disagree with the premise, but even if it applied, I also think it would not require the outcome the district court reached. But as to the premise itself, the inquiry of either Mullane or Matthews is an attempt to rely on the due process clause to impose additional procedural requirements beyond those already required by statute. That's the very nature of either the Mullane or the Matthews inquiry. So under the rule of Nishimura and Thurasigium, you never get to that inquiry because the procedures that are required are simply those required by statute, nothing further. The entire point of the Mullane or the Matthews test is to potentially require additional procedures. And that's
not what Mullane does. Mullane is all about notice. It's not about what procedures you're required. It's about notice. And what we've said in FERC cases and in FDA cases and in all other sorts of cases, that if an agency is going to take summary action, the agency at least has to provide you notice of what the basis is for the action.
I guess a couple of responses to that. One is that we believe that notice are part of the procedures, but even if you thought it wasn't strictly a procedure, it's pretty clear that the rule of Thurasigium is the entire scope of rights that can be claimed under the due process clause is only those provided by statute and nothing further. So I don't think that can be separated out from procedures in any event that the rule would encompass it.
Does the government agree that these immigrants have some interest in not being unlawfully removed?
They have some interest, but that is...
I mean, under JGG and AARP from the Supreme Court stay decisions, do they have some liberty? I mean, they don't have a liberty interest to remain because they're here unlawfully. Do they have some interest in not being unlawfully removed?
They have some interest that can only generate those rights that Congress has provided. That under the rule of Thurasigian and Nishimura, while there might be an interest that can be...
Do they have that statutory right, do you think, under IRERA?
No, I don't think so.
A right to not be unlawfully removed or not unlawfully be subject to expedited procedures?
They don't have a right to any additional procedures beyond those that are required by the statute, and that was the entire basis of the district court's decision. So we think that the reversal is required here because the reliance on the due process clause to impose additional procedural requirements beyond those that Congress provided necessarily violates Thurasigian and Nishimura.
So the government's position is that if notice were to be required, it would have to be explicitly set forth in statute.
If Congress had provided for such notice, that would be an enforceable right that the aliens would possess. But Congress, there is not an allegation this is required as a matter of statute, only that it's required as a matter of the Constitution, wholly aside from what the statute provides.
So what are we to make of the significance of the Supreme Court's language in the ARP v. Trump and Trump v. JGG, where the court says, well, the process is one thing, but there has to be at least notice in time for you to be able to avail yourself of the process.
So I think AARP is addressing a different context that doesn't apply here for at least three different reasons. First of all, it is addressing a different question fundamentally. It's not addressing removal under Title VIII, which is a context that has a very robust, line of precedents running 130 years that's controlling here. It instead addresses the Alien Enemies Act, which is a much more narrow context that addresses different things and different concerns. In particular, second, it addresses a fundamentally different inquiry. It's not saying the government is saying you're removable because you're an alien and don't have a right to remain in the United States. It's the United States fundamentally bringing allegations of fault. They're saying in that context, we are alleging that you are a member of a foreign terrorist organization that is waging a predatory incursion or invasion of the United States. That is a fundamentally different inquiry. When the government brings allegations of fault against a person and seeks to deprive them of their liberty on that basis, that's a very different constitutional inquiry than what is presented here.
Mr. Einstein, let me ask you why this ICE guidance document from February that was just published in October, why was this not part of the litigation from the outset? Why is this not information that the government provided to the district court? Because now we have a decision from the district court saying these procedures don't comply with due process, but it was based arguably on an incomplete picture of what procedures were being used by the government. So I'm not sure I understand why this is being presented to us now. It wasn't presented to the district court, wasn't presented at the stay decision. And I think this guidance has implications both for the time bar issue, and I think it has implications for what is happening in terms of due process.
So several reactions, which may only be partially satisfying, but let me kind of go through how we got here, because I think that bears on why the record
This is important because, we can take judicial notice or not in large measure as a certain, as a matter of discretion. So I think it is relevant.
We certainly think it's relevant to the issues presented, although I think you would never get there. So first, let me explain why I think you would never get there, but then also why it's properly presented if you believe that the court's inquiry would reach that. The fundamental issue about continuous presence, we believe, is one that's not a case or controversy presented here, because there is no evidence in the record whatsoever that this has ever affected or injured an actual person. There is no allegation that anyone has said that I wasn't provided notice that I had, the burden was on me to show that I've been continually present in the United States for more than 2 years. And as a result, I was not able to make that showing. That unless someone can come forward with allegations of that sort, there is no Article 3 standing, and hence that's not presented. And so
how can you say that when there's declarations in the record from members of Make the Road who say that essentially they were detained, they weren't really told why, and essentially they're given some notice at the same time that they're told you have to leave the country, and they weren't, nothing was explained to them about continuous presence in 2 years. I think there's a declaration from somebody named Mary
There are two no's. So two responses to that. First of all, we think it is not presented because those two individuals are named plaintiffs and expressly disavowed seeking relief. And I think the court has to take them at their word that when they expressly disavow seeking relief, that isn't expressing disavowal, does not satisfy plaintiff standing inquiry. But even if you thought it was before you, and then Judge Rao, I very much do want to answer your question. Those declarations only say I was wrongfully removed. They never say what notice they were provided, and they certainly don't say as a result of this notice not being given to me, that's the reason I was wrongfully removed. That's what you would need to do in order to connect the alleged constitutional defect to any actual inquiry, and there's simply no attempt to connect that. So Judge Rao, I set that up because I think it's important as to why the record is undeveloped. Plaintiffs have never, this is effectively a phantom problem that it never appears to have affected any individual ever. And that's why the record.
I understand that's the government's position, but the plaintiffs here have made a facial challenge to whatever procedures are being used for expedited removal for the expanded designation. And so I understand it's the government's position that maybe they don't have standing, that this is barred for a number, any number of reasons. But in the district court and in the stay motion, there's still a whole discussion about whether the procedures were adequate, and we didn't know what the procedures were. I just don't, do you have anything to say about why the government didn't share that at some earlier stage of the litigation?
I think it is precisely because it appeared that it affected no one and the record was undeveloped on that. And to the extent the record is undeveloped because it has affected no one, I think the right outcome here is to dismiss or a rejection of those claims on standing.
We did eventually show it to us. So if it's completely irrelevant, why did you even show it to us?
Well, it is certainly to the extent that there is no Article 3 jurisdiction is irrelevant. Obviously, we recognize the possibility that you might disagree with us, and therefore we presented it in that context. And
why didn't that logic lead you to present it before then?
I'm not exactly sure, Your Honor. Certainly briefing was conducted in a very accelerated manner in the district court. Although plaintiffs filed in March, they didn't file their Section 705 relief for some time, and it was a very accelerated briefing schedule that the government was put under. And so I think that's part of the reason. In any event, we do think it's properly the subject of judicial notice, as well as to answer, I believe the question Judge Rao may have presented or at least alluded to, the 60-day statute of limitations here is jurisdictional in nature, and it's of course plaintiff's burden to establish that jurisdiction exists.
Well, I mean, this guidance wasn't made publicly available until October. And so does that mean maybe the time bar resets?
I guess
if they're challenging those procedures, then I'm not sure how the time bar would apply. And I think it's interesting the government didn't really press the time bar issue at the stay motion. It's jurisdictional, so we have to think about it in any event. And so there seems something a little shifty about the fact that this guidance wasn't provided. We had an affidavit setting out some of the procedures that the government was using, but not the guidance itself. Perhaps you don't have anything else to say about it. But it seems that the time bar may well be off the table, given that there are new procedures that were written that ICE is implementing with respect to the designation. It doesn't mean that there aren't other threshold issues, but perhaps the time bar issue is off the table.
I guess a couple of responses to that, Your Honor. First of all, I don't think that the procedures were in many ways public. The 2019 guidance was part of the public record in the first Make the Road case. There is not any, plaintiffs have never identified any material changes between the 2019 and the 2025 guidance. And indeed, the stay opinion at 58 explains that, quote, the expansion order provides no added procedures beyond those already in place, end quote. There's effectively no change in the relevant procedures. And in order for plaintiffs to satisfy their burden to establish jurisdiction under the jurisdictional time bar, they would need to establish that there was some change in procedures in the prior 60 days that caused them injury. And there's no allegation at all that the 2025 procedures change from the 2019 procedures, which were very much public, in any material way that would cause them injury and thus would, put them within the jurisdictional time bar here.
Did the government argue specifically that they were using the same procedures as in 2019?
We certainly argued the 60-day time bar below. I believe we did that. I'm not sure exactly.
Did they say we're doing the same procedures as 2019?
I believe we did. I'm 90% confident in that. We can certainly find that site and provide it to the court by 20HA if the court would like us to do so.
Can you talk about the plaintiff's argument that guidance to ICE does not apply to CBP? I know in your reply brief, I got it here, you say, ICE is primarily responsible for processing expedited removal for aliens encountered in the interior, but it is, I think, the case that at least some of the times CBP is doing the work. So can you give us any assurance that the guidance in the February 2025 ICE guidance is being followed by CBP?
Your Honor, I believe that's my understanding, but let me confirm with my client that that's the case. We can inform the court about that. My understanding is certainly that nothing has changed, and certainly I don't think the relevant thing that plaintiffs have found fault with, the lack of notice as to is any different. But I believe probably the more relevant procedures is being given an opportunity to provide those documents if you claim to have them. Let me take that back and try to nail that down.
I'd be grateful for that clarification.
Yeah.
I also, on the topic of notice, it's not clear to me from the record, maybe it should be, whether an alien in the situation relevant here is told you are being expeditiously removed. You are being subjected to expedited removal procedures. Are they told that?
They're certainly told that they're being subject to removal procedures. As to the specific notice, I would have to look at the form. As I don't know if it uses expedited or provides the statutory site. I believe so. Even if it didn't, I don't believe for purposes of plaintiff's relevant claim that would matter. The durational presence requirement is best understood as a affirmative defense, and as the Second Circuit has recognized in the Mitchell case.
So, I mean, I would just put my cards on the table a little bit here. I think I'm likely with you that you don't have to tell them all of their affirmative defenses, and you probably don't have to tell them, hey, you can get out of this expedited removal procedure if you show us you've been here for longer than 2 years. But I think it's a little different to not even tell them that they are being subjected to the expedited removal procedures. It's sort of like you don't have a duty to tell a murder defendant that they have an affirmative defense if the crime was committed, if the killing was committed in self-defense. But you do have to tell them that they're being charged with murder. If they don't even know they're being charged with murder, how would they know to assert the affirmative defense that the killing was in self-defense?
Understood, Your Honor. They are provided the form. It is in the record. I apologize. I don't know.
So my reading of the form is that it does have the statutory provision for expedited removal. I think it's a lot to expect the immigrant in that situation to have memorized the U.S. code and know exactly what that provision. I'm not even sure it's the U.S. code. It may even be an INA statutory provision that's given. So, and I think, help me out here if I'm wrong, they don't have access to Google to look it up. They don't have access to an attorney to tell them what the statutory code is. Is there any way that if all they have is the statutory code that they could know that they're being subjected to expedited removal?
Certainly, I know they're given an opportunity to talk to outside parties if they claim that they have, they could provide relevant documentation. The guidance does say that. As to yes,
they could talk to an outside party if they say, I've been here longer than 2 years. That's what you're saying, right?
Yes, Your Honor. They
wouldn't even know to say, I've been here longer than 2 years if they don't know they're being subjected to expedited removal.
Certainly, they know from the notice what the statutory provision they're being subjected to. I
don't expect them to have memorized every statutory provision in the INA.
Perhaps not, Your Honor, although certainly the United States requires citizens and all people here to they're charged with knowledge of an astounding amount of conduct that Congress may have criminalized in Title 18 that might not be realistic to expect that they know every single provision that they might run afoul of, and due process nonetheless does not, find that infirm. So that they may be subject to that. I'd further say, to the extent that that's a deficiency the court thinks is of constitutional relevance, relief should be narrowly tailored to that particular deficiency, not the blanket universal and maximalist relief ordered by the district court.
When you say universalist and maximalist relief, I'm trying to understand, the order is two sentences. The first sentence is that the motion for stay of agency action is granted, essentially. And then the second sentence is that the effective dates of implementation and enforcement of the January 21 designation notice and the January 23rd Huffman memorandum, insofar as it implements the January 21st designation notice, are immediately postponed and stayed. So that is what you are shooting at, right?
Not just that, Your Honor. It's also an opinion that explicitly refuses to conduct any tailoring inquiry and instead insists on the maximum possible relief that the court could issue, which I don't think is, disputably universal in its scope. And we think that's problematic for three separate reasons. First, it violates Section 1252 F1, which explicitly bars relief to non-named plaintiffs in this context. And so that itself is a dispositive bar here. Second, it violates traditional equitable principles, which apply to Section 707 as the Ninth Circuit is correctly recognized in the immigration defenders case, and it also flows from the text of Section 705, which incorporates traditional equitable principles by referring to preventing irreparable harm and preserving the status quo. And third of all, it violates Salerno by granting facial relief without satisfying the no set of circumstances standard. And plaintiffs do appear to agree that the Salerno inquiry, that Salerno would otherwise apply. They simply believe that Section 1252 somehow creates a never before seen statutory exception to Salerno that I don't think they've cited a single case for the proposition that Congress has ever created such an exception, let alone does so here in a provision whose manifest intent is to restrict the scope of judicial relief rather than expand remedies.
Tell me what you think 8 U.S.C. 1252 E3 means when it says that a person can bring a challenge to the validity of the system. What do you think subparagraph A of that means? What challenge can be brought?
So to the extent that you want to bring a facial challenge, that provision limits judicial review profoundly in ways that would or the ordinary rules would otherwise permit. Ordinarily, under the APA, you could bring a suit within 6 years of a claim accruing, and you could do so in any district court in the country. 1252 E3 restricts that very substantially. It says you can only bring it in DDC. You can only bring it within 60 days. That restriction is jurisdictional and does not renew under corner post every 6 years as it might otherwise if we were under standard APA rules. So the manifest intent of Congress in 12.
I'm not asking you about the deadline, the 60 days, or whether it can be brought in DDC. I'm specifically asking you about A. What does A mean?
What A means is that if you have a facial challenge, you have to bring it in these much narrowed ways that Congress has explicitly provided. It's not saying that facial relief is, we're dispensing with all the usual rules for facial relief, go wild. What it's saying is these challenges that otherwise could be brought much more broadly, up to 6 years anywhere in the country, instead, to the extent that you're going to bring them at all, you have to bring them in these very narrow confines. That's what it means.
Let me try it again. The text says judicial review of determinations under Section 1225B of this title and its implementation is available in an action instituted in the U.S. District Court for the District of Columbia, but shall be limited to determinations of Romanet 1, whether such section or any regulation issued to implement such section is constitutional. Let's stop there. So what claim can be brought based on that text, in your view?
In my view, this programmatic challenges that could be brought under ordinary principles of law are restricted under the scope of that provision. So that defines, if you have something that fits within the scope of that, the rest of the provision defines the much more limited ways in which you can bring such claims. And that is what that provision does.
So can,
I just say I didn't quite follow. Go ahead. But
I don't
please.
follow it all. So a plaintiff pursuant to that section can bring a claim seeking a stay of the implementation of a regulation or policy. Do you agree with that if under the grounds that it violates the Constitution?
I agree that I could. I guess my disagreement here, and I may not be articulating it well enough, is we don't read this provision as a specific authorization of judicial review. We view it as a channeling provision that says when you have one of these claims that you might have otherwise. And I think they are attempting to bring this under other causes of action, under other laws. I don't think they're specifically saying that this is their cause of action. That what Congress has done.
Well, they say in their complaint, this is in the heading of the complaint, they list this as part of the grounds for the cause of action. I mean, they list 1252 E3 and the APA and 13 and then as a basis of jurisdiction, they list this statute in 1331. I mean, there are some statutes that create a cause of action. There are some statutes that confer subject matter jurisdiction in a particular court. There are some statutes that do both simultaneously. They say this is your cause of action and we are conferring jurisdiction. Why isn't this one of those statutes?
Your Honor, I think that they have not attempted to bring it under the APA. They could not do so under the Make the Road decision. The language that provides that the scope of expedited relief is in the sole and unreviewable discretion of the Secretary means that sole and unreviewable discretion precludes an APA cause of action. We think that as a result, they are bringing it under something.
Well, you can have an APA cause of action under that says that what the agency does is unconstitutional. I mean, 706 says that that's one of the grounds for scope of review, right?
It says that that's one of the grounds for the scope of relief. I don't think that's the cause of action. And I think just as Section 06 essentially provides a standard review, we wouldn't think that that provides a cause of action. We also don't think that 1252
So
E3.
contrary to law, cause of action doesn't include contrary to the Constitution. That's what you're saying.
I think that provides a standard review for an otherwise applicable cause of action, but your cause of action is very likely to be either Section 702 of the APA. It may be something that vests review directly in this court, for example, orders coming out of the FCC, or it could be an implied cause of action in equity. If it's a constitutional claim of this sort that has to be brought outside the APA because the APA does not provide a cause of action here, I think it would be an implied cause of action in equity.
I want to make sure I understand your position. So you're saying that there is no cause of action under the APA for agency action that violates the Constitution?
Not as a general matter, Your Honor, but here this court has recognized in the
yes or no, one can have an APA claim that makes an allegation that an agency action violates the Constitution.
Not always is the answer. The APA often will provide you a cause of action, but sometimes it might be precluded. And it might be precluded, for example, because Congress has otherwise denied an APA cause of action, as it has here in the as recognized in the Make the Road decision, Make the Road 1 decision. And so as a general matter, you would likely have an APA cause of action, but there might be circumstances where
what work does 1252 E3 do? You're saying it doesn't create a cause of action. It doesn't confer jurisdiction. What is it?
It is a channeling provision that greatly restricts the availability of judicial review. Otherwise, judicial review would be available in any court in any federal district court in the country and would be available for up to 6 years. Congress in that provision has greatly restricted it. And that does quite a bit of work. It says that, of all the federal district courts in the country, all but one of them are no longer available to you. And it says that, you do not have your ordinary 6 years. You have only 60 days. You do not have a ordinary statute of limitations that's waivable. You have one that's jurisdictional. That does quite a bit of work, we think.
So it becomes jurisdictional because of 1252 E3, 60 days becomes jurisdictional, yet the statute doesn't confer jurisdiction. So how is it a one-way ratchet? Explain that.
It's not a one-way ratchet. It's a restriction on the jurisdiction of the court because it speaks to the authority of the court to order a remedy. That 1252 F1 also restricts the court in terms of what remedies it can order, but no one thinks that 1252 F1 is a conferral of jurisdictional to bring a different cause of action. It simply restricts the relief that a court can order under an otherwise valid cause of action.
Mr. Ornstein, in Make the Road 1, this court held that designation decisions are committed to agency discretion by law based on IRERA. But there is a footnote that says we don't decide something to the extent we don't decide whether a constitutional claim could be available under the APA or otherwise. So can you have a matter that is committed to agency discretion by law, but reviewable under the APA as a constitutional claim?
We don't believe so, Your Honor. It's generally recognized that, so there is a debate whether or not committed to agency discretion is a jurisdictional bar, and there's I believe, long festering circuit split on the issue. But at a bare minimum, when Congress goes to the trouble of committing something to the agency discretion, that means that the APA cause of action, which speaks to especially administrative discretion, is not available. That doesn't mean that you wouldn't necessarily be able to separately rely on, say, an implied cause of action at equity, as like this court is recognized.
So the district court here explicitly said it was not deciding an APA claim, presumably to avoid Make the Road 1. So I mean, do we have to understand what the district court did here as an equitable constitutional claim, as treating the due process claim as an equitable constitutional claim?
I believe so. I mean, I think by process of
what else could it be?
Exactly, Your Honor. By process of elimination, I think that's what it has to be.
In which case, the APA doesn't apply to equitable constitutional claims.
I don't believe that there's case law specifically on that point. There are some instances where this court has imported the Section 706 inquiry without specifically an APA cause of action. We don't think that would be reviewable here, but I'll acknowledge I don't think that there's any case law specifically controlling on that point.
There are cases where we have used 706 without an APA cause of action.
Yes, Your Honor. Say, for example, Congress has vested review of an order issued by the FCC. You have to file a petition for review in this court in 30 or 60 days. It may not specifically provide what the standard of review for that is, for that review of that agency action, but this court would then look to Section 706 and say that's where it gets the arbitrary and capricious standard for reviewing that claim that's raised to you by a petition for review.
Oh, that's very different, though, than importing an APA remedy. Or is it different?
We think it's different, and we think it certainly, could be preclusive here as well.
Going back to 1252 E3A, I'm going to use a lot of ellipses here, but basically reads, judicial review is available for determinations of whether covered regulation is constitutional. And what is the remedy when that happens? What do you think the remedy should be when that happens?
So we're expressly in the realm of interim remedies because there isn't a final judgment. So I think that's important here. And so it potentially could be a preliminary injunction, although there are severe problems with that. And that's why plaintiffs did not even elect to request that, or a Section 705 stay. But as to Section 705, we think it incorporates traditional equitable principles. We think that follows from the text of 705. We think it also follows from the fact that federal courts universally use the winter preliminary injunction standard to determine whether or not a Section 705 stay should be entered. And because equitable principles apply, the rule of CASA and the usual rules limiting the scope of equitable relief and precluding universal relief also apply in this context. And so even if you didn't have 1252 F1, which we think is a dispositive bar here, ordinary traditional principles of equity apply to Section 705 and would limit the scope of the relief that could be issued by the district court in an interim posture.
What about the final judgment remedy?
So we think that applies to that as well, but we will acknowledge that that is a different and perhaps harder inquiry for the government, whereas Section 705 says that you may issue relief. Section 706 admittedly says you shall set aside. This court long ago crossed the bridge of saying shall set aside does not mean a mandate. It's in fact permissive and has also applied equitable principles to that, but it does not, its remand without vacator standard is a bit different. It's applying equitable principles, but it's applying a different, it's certainly applying a different standard.
Yeah, so I think I understand. I think that you're saying the final relief for someone seeking judicial review of whether a covered regulation is constitutional could be vacatur of the covered regulation. Is that right?
Yes, Your Honor. Maybe I should put it this way. We think CASA also applies to Section 706, but we'll acknowledge that's a harder question than whether or not it applies to 705, and whether or not you think it applies to 706 at all. We still think it absolutely applies to Section 05, and those questions are distinct.
Okay. So if we're in a situation where a meritorious claim is going to lead to vacatur, I'm not saying we're there now, but if we were in where the final relief would be vacatur, then the interim relief would be a stay, right?
So we don't think that the Section 705 is just a preliminary vacator. And the way that federal courts have universally treated it is applying the preliminary injunction factors. They're not applying the Section 706 vacator standard and just replacing actual success on the merits with likely success on the merits. They're instead applying the preliminary injunction standard of winter, and we think that's the correct inquiry for 705.
But you seem to be like digressing a little bit into what the standards would be. I'm just trying to figure out what the relief itself would be if it was going to be awarded. In a case where the final relief is going to be vacatur because a covered regulation is unconstitutional, the interim relief would at least sometimes be a stay of the covered regulation. Is that correct?
It's correct that there could be a stay, but we think that stay is governed by CASA and traditional equitable principles.
Okay, so there could be a stay, but you're saying it wouldn't be, it would not provide universal relief. It might only provide relief to a named plaintiff.
Right.
Okay. And then that leads to, I thought that's where we were going to end up. And that's clarifying for me, make sure we're on the same page so far. I think the government's position, as it was in the previous administration, is that universal vacatur is just as problematic as a universal injunction. But assuming that's wrong, as I think most of the Supreme Court thinks it's wrong, then wouldn't universal vacatur be the appropriate relief for an unconstitutional covered regulation And wouldn't a universal stay be the appropriate preliminary relief leading up to that universal vacatur?
I don't believe so. So let me first clarify, I believe, the position of the government and then explain why we think that's different. The government's position does continue to be that Section 706 does not authorize universal vacatur. I will certainly acknowledge that this court has held otherwise. And indeed, I believe Chief Justice Roberts famously said that you do these things multiple times before breakfast each morning. And so I will certainly acknowledge that argument is off the table in this court in this posture. But that is nonetheless that position. I believe it has been accepted by one circuit. It's not, it's certainly a position that we think is well supported and may, ultimately arrive at Supreme Court, but for present purposes, it is highly theoretical for this panel. So we acknowledge that this court's precedents provide 706 what applies universally. Why is 705 different? I think several reasons. One, the text of 705 is profoundly different than 706. 706 says shall set aside. Section 705 says just may, and it refers to traditional equitable principles in terms of preventing irreparable harm and preserving the status quo. And the Supreme Court has a very long line of very robust precedents that make clear that departures from traditional principles of equity are extremely difficult to establish and are only done in the, where there's the clearest possible language. That's in the Heck case, that's in the eBay case, that's in the Weinberger case, the Starbucks case. They've said that many, many times. And so because Section 705 doesn't just not clearly provide an exception to traditional equitable principles, but seems to expressly incorporate them, then we think that applies. And notably, outside of the administrative context, that is exactly the rule that, if you have
if that's right, does that mean that the stay of the Clean Power Plan was inappropriate? The interim relief where the Supreme Court reversed our court and stayed the Clean Power Plan, leading eventually to a final judgment in West Virginia. The Supreme Court was wrong to issue a stay for the Clean Power Plan?
I'm not prepared to specifically speak to the facts of it, and CASA does acknowledge that there will be some times where, in order to provide complete relief, in order to provide complete relief to the named plaintiffs, it may have to be that sort of broad relief, but you can't just simply do so without, going beyond what's complete relief to the parties. So I'm not prepared to speak to the specific circumstances there. I mean, obviously, the Supreme Court doesn't, decide issues that it doesn't talk about. And so I can't specifically speak to that, but maybe.
Ms. Ramstein, can I ask, I take your textual arguments that 705 specifically refers to pretty much all of the traditional equitable principles, and 706 makes no mention of them. Does the government have any arguments, however, about the history of the APA or why 705 and 706 might have been written in those different ways? I think it's very hard to kind of divorce those two provisions from each other. And so I'm wondering if there's like some further historical evidence.
Not specifically that I'm aware of, but I think historical practice could be pretty instructive here. In particular, Section 705 stays basically didn't exist as a commonly sought remedy until about 5 years ago. There is very scant case law on it. And, it is a very late discovery if it provides the same sort of, blanket relief in an interim posture. I mean, essentially, you would have administrative lawyers, I believe, committing
Isn't that in part because normally you could just get an injunction, so you wouldn't need 705? And part of the problem is IRERA does one thing I think everyone agrees on is it doesn't allow injunctions. So in an ordinary agency case, you could just get an injuction. You could, maybe. I mean,
you potentially could, but it's well established those injunctions are subject to the narrow tailoring principles. Right. And so if it was the case that Section 05 was always available that whole time to get universal relief, you have essentially administrative law lawyers committing like 8 decades of malpractice, failing to, seek the much easier remedy. And so the fact that they weren't doing so and didn't understand it to be so, I do think is instructive on what, was intended.
So do we have to have the same rule for 705 and 706? I mean, the government's position is that, yes, we do. You can't get universal relief in 705 and you can't get universal relief in 706, except maybe in exceptional circumstances where it's shown that universal relief is required.
So I don't
But
think
you're also asking us to split the way we think about those under our current precedent, which is, obviously we can't revisit our precedent suggesting that universal vacatur is available under 706, but we could treat 705 differently.
you certainly could, Your Honor. And just to clarify, our position is not that 705 has to incorporate CASA because 706 does. It is both of them incorporate CASA, but 705 absolutely can independently incorporate traditional equitable principles in a way that Section 706 might not. And that flows quite readily from the profoundly different text of those two provisions, where one says shall set aside and the other says you may preserve the status quo to prevent irreparable harm. Those are radically different texts. It should not be surprising that might lead to different outcomes for the two different provisions.
That's not the government's sort of top line position. The top line position is that these traditional equitable principles are in both 705 and 706.
That is our position, but not specifically. But our position on 705, our frontline position on 705 is not a derivative argument based on 706. It's based on the text of 705 itself.
I just want to understand something based on these exchanges. So the government is not contending that 1252 F1 categorically divests a district court from entering a stay under 705 aided by 1252 E3A.
1252 F1 certainly does not preclude a court from ordering relief as to named alien plaintiffs. As to such plaintiffs, 1252 F1 is not a restriction on remedies whatsoever and would not preclude jurisdiction. On top of that, this court recognized in Make the Road 1 that the 1252 F1 does not bar declaratory relief. And so 1252 F1, at least where you have named plaintiffs, is not going to be a barrier to having a case or controversy. But it certainly is an absolute prohibition on awarding relief that enjoins or restrains as to any non-named alien plaintiff. And we think that absolutely is the case here. As the Supreme Court has, go ahead, Your Honor.
So if I look at the language of the order that's at JA1, and let's suppose that, just for the sake of this hypothetical, that we think that the court had it right, but the scope, we agree with you on the scope, then what the order should say is that these are stayed with respect to the plaintiffs, and just make that explicit instead of just saying stayed without any reference to these plaintiffs. Is that what you're saying a correct order should do?
I don't believe so, Your Honor. If I'm understanding the question correctly, that would be a stay as to the parties, but the relief would still be in place as to non-parties. If that would be the case, I mean, I think that would violate all sorts of principles of Article 3. And it would be providing advisory opinions to parties not before the court. So
Well, I'm just trying to, I'm sure I didn't ask the question very well. I guess all I'm saying is if you had a meritorious case where a court was authorized to stay a regulation, are you saying that the way that the order should be drafted, it should say this regulation or this policy is stayed with respect to any proceeding involving the named plaintiffs? That's the way you say that the order should be written. I'm just trying to understand what your position is.
Understood, Your Honor. And it's a bit of a wrinkle here. So if you had a situation where there was both like an organization and named plaintiffs, and the district court had granted a stay as to all of them, then the right remedy would say that it should be reversed as to the non-named plaintiffs, so the organizations, but allowed to stay in place as to named alien plaintiffs. So if that were the only issue, that's what the order should be. There's a wrinkle here in that while plaintiffs here are both organizations and individuals, the Section 705 stay here was sought only on behalf of the organization and not on behalf of any individuals. In fact, the individuals expressly disavowed seeking a 705 stay themselves. So in this posture, the only relief granted that's up on appeal is by 1252 F1.
I guess I'm not understanding that, because why is it the case that if relief is too broad, the only thing that we can do is to set it aside completely, as opposed to narrowing it to whatever the statute and the Constitution says it should be narrowed to?
Your Honor, I agree with that principle. I just think here, when you narrow it to its proper scope, there is no proper scope. So it needs to be reversed in its entirety. There's no relief that was granted here that doesn't violate 1252 F1. And that's why an outright reversal is required. If there were relief that were granted to individual alien plaintiffs, and that had been part of the district court's order, then then the decision shouldn't, if 1252 F1 were your only issue, you should leave that in place, but that's just not the posture in which this appeal arises.
Out of curiosity, in a different case where there were individual alien plaintiffs seeking the interim stay, and the order read, the relief provided is a stay. The court provides relief just to the named individuals. How would the effect of that be any different than the effect here?
I think it's the universal scope that's different. I mean, if that were the case, it would only apply to a very small number of people, but instead it applies to the entire universe of aliens that might enter the United States.
So if a court stays a rule that the government can continue treating that rule as if it hasn't been stayed with regard to everyone who wasn't a plaintiff?
I think when a court orders party-specific relief, that is how it in fact operates. Then the government.
That's true for an injunction, but an injunction runs to an individual person. Like you can't, you, John Doe, cannot do something, or you, John Doe, must do something. But a stay runs less to an individual person, and it runs more to a decision that has been made, either an adjudication or a rulemaking. And once a decision has been stayed or vacated, it's as if it doesn't exist. It's as if the decision hadn't happened. And once we're in a world where a court has ordered that a decision has not happened, how can the government continue to act as if that decision has happened?
I think, first of all, even as a Section 706, I think partial vacators have sometimes been ordered. It is not necessarily the case that the court has always done maximalist relief, even within 706. But, as to Section 705, Congress clearly intended to apply traditional equitable principles, of which party-specific relief is a bedrock requirement of centuries of Anglo-American law.
But I'm not sure I agree, not sure I disagree. But for 706 final judgment vacator, not partial vacator, but just vacator, you would then concede that even though the judgment was obtained only by individual named plaintiffs, that the government cannot continue to treat as if it exists the government decision that has been vacated.
I don't believe it would certainly depend on the language, but if a district court expressly entered party-specific relief, I think the government would certainly be, and made the vacator party-specific, I think the government would certainly be within its rights to treat that party-specific relief as party-specific relief.
Have you ever, can you name us an instance where that has ever happened? Where this court or any court has said in the vacatur context, ABC company prevails on their APA claim and this rule is set aside, but it's only set aside with respect to them, to ABC Corporation. The agency can still enforce the rule against everybody else.
Not specifically. So again, this would be within the context of Section 706. But 706, even within that context, this court, obviously has its remand without vacator standard. It has also issued vacators that are less than complete in relief. It often is time limited, or sometimes limited in scope. There's nothing conceptually different from a vacator limited in scope as to parties or as to aspects of the rule. It's less than complete vacator. I can't cite you specific.
If you can't tell us an instance where that has ever happened under 706, why should we believe that that's the proper way to proceed, or would be the proper interpretation of party-specific relief under 705?
Because
I mean, a vacatur or a stay a stay doesn't have a different characteristic under 705 than it does under 706, other than whether it's temporary or permanent.
Your Honor, we simply disagree. The texts of Section 705 and 706 are profoundly different. 706 says shall set aside. 705 says you may issue a stay and then it expressly incorporates traditional equitable principles. And those traditional equitable principles.
Understand may and shall, but it doesn't. That begs the question of whether a stay or under one means something different than a stay under the other.
I agree that it raises that question, and our answer to that is that 705 has very different text and must incorporate, does incorporate traditional equitable principles, including the CASA principle and including the ordinary requirement that relief is generally party specific. And notably, it's well recognized. I believe the Supreme Court said in the Weinberger case that the essence of equity is flexibility to mold a decree, and an absolute requirement that relief must always be maximalist is antithetical to those equitable principles that Section 705 is going out of its way to incorporate in multiple instances, which should be enough on its own. But then you have an overlay of that, of the Supreme Court has said in multiple cases like eBay and Weinberger and Hecht that you need exceptionally clear language to depart from traditional equitable principles, and you can't find anything of the sort in Section 705.
So let's suppose the court agrees with your conceptualization of it. So you have a case where a stay under 705 is entered, and it says that this policy is stayed with respect to these named plaintiffs because we find that the policy violates the Constitution. So that's what district court order says, and that is affirmed by our court. Isn't the effect of that practically going to be that when from that moment forward, when the government attempts to implement that policy against anyone else, they will argue that the policy is unconstitutional and the government will be collaterally stopped? from really prevailing otherwise. And so the effect of it is going to be that that policy is stayed as to anyone, or at least anyone who makes the argument.
So the answer to that is a bit complicated, and it really depends on the posture. So certainly to the extent that a district court issues party-specific relief, the government is bound by that and must abide by its terms as to the parties. As to non-parties, certainly in the district court, there is not otherwise binding effect. To the extent that this court would decide something in a binding published opinion, then it becomes a bit messier. There is sometimes the government will take a non-acquiescence posture in other circuits. Certainly to the extent that the Supreme Court decides the legal issue on the merits, at that point, the scope of relief is essentially something of a moot point, because then the answer is what it is, and that's the law of the land from the highest court. To the extent that this court would do something in this circuit, the government, very typically follows that, but it might take a different position in other circuits that might have different results. Or and that, for example, if there's an adverse social.
But doesn't this provision channel all actions to the U.S. District Court for D.C.? So why wouldn't then all subsequent actions be essentially controlled by this first order?
Certainly all programmatic challenges that could be brought. And so it gets a bit messy. So that it channels programmatic challenges, but doesn't necessarily channel individual as applied challenges. So it's conceivable that it might arise in a different circuit in a way that would present something different. And so, for example, if the government gets an adverse Social Security disability decision in the Second Circuit, it might take it continue to apply what it believes is the correct legal principle in the Ninth Circuit. And so there are quite a number of factual permutations. So I guess the bedrock principles are, obviously the government must follow party-specific relief as to the parties. Where a court issues a binding decision, that may practically have the same effect or a similar effect as broad relief, but that is not invariably the case.
Are you aware of any individual challenges, for in individual removal proceedings raising these due process questions? Is there litigation in other circuits?
There is, there have been challenges to expedited removal in the context of the invasion proclamation that I think may have raised similar issues here. Essentially, I think it can come elsewhere. Notably, there is exceptions for people. There's an exception in 1252E for citizens, lawful permanent residents, for asylees or refugees. So if you have some sort of durable status, you could bring those as challenges elsewhere, and it may arise elsewhere. And if you said the procedures were deficient, that could arise in a different federal district court.
Can I just also ask, given the government's position that this expanded designation is a very important policy initiative, and given some of these arguments about universal relief, I'm just, the government hasn't sought a stay at the Supreme Court after the circuit denied a stay. Is that correct?
Yes, Your Honor, though, actually, and certainly I was going to close the argument by renewing our request for a stay pending appeal here. Now that you have the benefit of full briefing and oral arguments, we would respectfully renew our request for a stay pending appeal, as this case may certainly, take some time to resolve. Certainly, this court's answer might not be the final answer to it. So we would renew that request. Certainly, this court took quite a bit of time to decide the stay pending appeal, and we did not go to the Supreme Court during that time that it was pending. We had, and then when the stay decision was finally came down, it came down very close to the date of oral argument, which is why I'm renewing the request to you now, instead of perhaps why we went to the Supreme Court in a posture where we didn't yet have an answer. I mean, technically speaking, I think our request for even an administrative stay remained pending for over 2 months.
All right. Any other questions?
Yeah, thank you.
All right. We'll give you some time on rebuttal. Thank you.
Thank you, Your Honors.
Mr. Balakrishnan.
Yes, that's right. Good morning, Your Honors. May it please the court. Anand Balakrishnan for the appellee in this matter. I just want to start with sort of a quick factual clarification and about something that I think might have confused the court, and then maybe proceed to sort of some of the due process notice issues after that. I think the first thing is I think Judge Wilkins and I think the stay panel had mistakenly believed that the individual plaintiffs, Mary and John, who were apprehended in Texas and put into expedited removal and removed after 10 years, they are not members of the organization Make the Road, and we've never identified them as such. And so I just want to, for the record, clarify that and also just point you to the correct record sites. I think that for the membership records of the organization Make the Road, you'd look at the Fontaine Declaration, which is the Joint Appendix 158 through 159, lists 6 individual does who are members of Make the Road, and those are the individuals whose standing Make the Road is predicated on, and the stay motion as well. So I just wanted to make that clear up front so that there's no confusion. I think that I'd like to next turn to sort of where I think Your Honor started the questioning, which is on this issue of notice. Of course, we agree with, that the notice is inadequate. I think I just want to be clear that there's sort of additional problems even beyond just sort of like the lack of notice. I know that Judge Walker had questions as to why, comparing it to, for example, an affirmative defense in a murder case, for example. But I think that the key difference here is the speed of the process, right? This is a process which, and this is in the record, and congressional studies have been done of this. This is a process that can occur in hours, less than a day, in which someone is picked up by an immigration officer, given a single sheet of paper, detained, all of their belongings removed from them during the detention process, not able to contact any third person, let alone a lawyer, and then removed from the country. So this is a place where notice is absolutely essential, particularly of
Isn't
such
the
a
process inconsistent with the ICE guidance that was just made public?
Is it? I'm sorry.
I said, isn't what you've just described inconsistent with the ICE guidance that was provided, which suggests that there's a reasonable amount of time to contact a third party, to get documents, to show continuous
Right.
presence?
I mean, there is a statement in there that they, will be given, but it's entirely in the discretion of the individual ICE officer. And so this is a place where it's a single agent gives them a piece of paper, says you have some period of time. That person is then detained, shipped off anywhere in the country. I don't have any clue how this process is supposed to work in practice, particularly when the only check on it is that individual officer who's supposedly in their discretion providing them with time. That person, and this is, again, it's in the numerous declarations and reports that person, are they going to be able to contact people? When they contact that person, how is that person supposed to get documents to which ICE agent? Nothing about this is set out in this. It's facially impossible.
Let me describe a situation, and then my question is going to be, is there evidence in the record that this has happened? You don't know the situation yet, so let me describe the situation. So someone's picked up, is told you're being subjected to expedited removal. That person says, I've been here longer than 2 years. The government says, I'm not going to give you a brief but reasonable opportunity to show that. And that person is removed.
Your Honor, I would have to, I don't want to answer that right now just because the record's quite large. So I don't know whether there is anything that meets that specific example. I will say that my recollection of the record, I think the following examples are certainly in there. So with the individual plaintiffs, not party to the stay motion, but their declarations in there, they provided evidence. They actually provided evidence to the immigration officer, right? Because they were visa overstays. They didn't enter without inspection. So they had some documentation which said that they overstayed the visa. They said that they had been here for, I think, around 10 years. All of that was written down on the ICE form, and then they were deported. So this is a situation, it's like one of these things where there might be examples, I don't know. I'd have to
But
check,
that, I mean, that may be an example of a perfectly fair process that led to an erroneous decision, an erroneous adjudication. But it doesn't sound like there's any evidence in the record of the denial of a brief but reasonable opportunity to show you've been in the country longer than 2 years.
I can't say that there is at this moment. I'll check. And if there is some, I'll
And
inform
then
the court.
here's a
But I
friendlier
understand.
question, I think. The government was not able to confirm, hopefully they will in reply, but they were not able to confirm that an alien in the situations that matter here are told you are being subjected to expedited removal. Do you know if they're being told that?
I don't know. I was looking at the record to see, so I also can't say. I would need to check again and would be happy to sort of submit like something on both of these questions.
Okay, I mean, it might be it'd be convenient if they can show something helpful to them, but it might be your burden to show as the party with the burden of proof here, that the process does not include a statement, written or verbal, to the alien, you were being subjected to expedited removal. That may matter to me if you can prove that.
I understand your question and your request. I would just, and I think this goes back to what I was saying before your questions, which is even on that though, I don't think even that would be sufficient in this context, right? Because, it's certainly better than like a bare statutory citations. You use the word expedited removal, but when we're talking about sort of like the continuous presence line, which is people who have been here over 2 years, because of the expansion of expedited removal, that includes everyone in the United States, right? And includes people who have been here for maybe 3 years, maybe 20 years, maybe 50 years. We're going to people who have been here for a long time, US citizen families, lots of connections. And at that point, I think that I don't think it's reasonable to think that anyone, even just sort of being told it's expedited removal as opposed to normal removal, would be sufficient to inform anyone that they're not subject to it if they've been here for over 2 years. And I don't think, this is sort of part of the Matthews balancing test, I think, which is I think it's like common sense, of course, that having really just even that bare amount of information, if you've been here for over 2 years, you're not subject to expedited removal, would certainly decrease the risk of error. And I'm not sure how it would be overly burdensome to the government to do that.
I mean, so here's kind of how I'm thinking through this part of the case. Congress has made a policy choice. You will be expeditiously, if you're here illegally, you'll be expeditiously removed unless you've been here longer than 2 years. So for someone who has chosen to be here illegally in violation of our laws, due process does not, from a due process perspective, it's not too much to ask that if someone here illegally wants the special non-expedited removal procedures that Congress has kind of graciously afforded them, it's not too much to ask that they ask for them.
I understand. And I think that might go back. It seems like underlying your question is a little bit the nature of the due process right and when it is triggered. And there, this is all in our briefs. And of course, this previous decision in this case, I think it's clear under Supreme Court precedent that, the line physical entry, we think, of course, it's met once you've reached the Rossingham line or the Yamataya line, 100 yards, 5 days, whatever, what have you. We're talking about over 14 years. But I think that there's nothing to indicate that any exception would extend so far as to over 2 years in the country. And I think that at that point, what we're talking about is, what we're talking about is creating minimal sufficient procedures to protect people who have clear due process rights under United States Supreme Court case law from being erroneously placed into expedited removal and erroneously.
Maybe part of that depends on how to read third.
Thurassingham, yeah.
Say again.
Well, I mean, I'm probably mispronouncing it.
I'm going to try Thurgassium. And I took a look at the respondent's brief in that case, which you know because you were on the respondent's brief, and it warns, if we lose this case, says the government submission is that the court should radically rewrite constitutional doctrine and expand the entry fiction to eliminate procedural due process rights, not just for those stopped at a port of entry, but for any non-citizen deemed to have entered the country unlawfully. It seems like you warned that if you lost the case, all of your now clients would have no due process rights. And now the government says they don't have due process rights.
But that's not what I think this might be an instance where we were wrong, but but less flippantly, I think that Thurassingham, of course, if the line were one of admission, Thurassingham would not have had to go through the due process analysis that it did to establish that Mr. Thurassingham was on the threshold of entry. It would have simply, the opinion would have been a lot shorter. It would have said he was never admitted. We're done. So I don't think that, and we can also look, and we've already talked about this, in AARP, of course, the Supreme Court there, its language was universal. It was just repeating this 100 years.
I think there's strength to your argument, both your reliance on AARP and your point about what the Supreme Court actually said in Thurgassium. So let's assume that your clients do have some due process rights. The government makes an argument that there's no such thing as process just for the sake of process. And I think all of your clients, as you've kind of defined them, all the members of Make the Road, are here illegally. So whether they get kind of expedited removal or non-expedited removal, the proper result is removal, right?
I don't know whether, I think maybe I don't know whether the proper result is removal. The proper result would be sort of procedures to the relief that Congress has afforded them. So that might range from, examples like asylum, withholding of removal. But, as you go further, sort of like outside of the zone of the border, there's more and more forms of relief that people may be entitled to under law that expedited removal cuts you off from. Would
you agree? And I think I did probably phrase the question too broadly, but would you agree that for someone who is here illegally, no asylum claim, they're not citizens, they don't have a visa, they're not permanent residents, et cetera, that for someone who's not here illegally, that whether they go through one stage of adjudication or whether they go through 14 steps of adjudication, that if they're not here legally, one step or 14 steps later, they can be removed?
I think if your question is about sort of like if we assume the following, someone has sort of entered, across the border in an undocumented fashion, there's two different processes, one shorter or longer or something, and they don't have a sort of valid form of relief. The end of it results in their removal. I think in most cases, yes.
In most cases, yes. What?
Yes, they would be, like, if they have no claim for removal. But I think that, but I feel like that's sort of flipping the due process question on its head, because there it's sort of assuming there is no relief for people. But I think it's clear, people do have forms of relief that Congress has made available to them that people will be entitled to. Even those at the border at a port of entry have the ability to claim various forms of humanitarian protection from removal.
Right.
But-
Then that gets into the credible fear question and the asylum question. And I realize you're litigating that. That's an open question for this panel. The emergency panel was unanimous in not thinking that there was a problem, or not ruling for you on that question. So if you put the asylum credible fear question aside and you're just talking about the group of people who have been here longer than 2 years, or who have not been here 2 years yet, but who will be by the time they're picked up, and we're talking about those people who don't have an asylum claim, it's almost like you've taken a class of imagine a class of imagine a due process claim that says the government is taking away my property without enough process. And the statute says they're entitled to 14 steps of adjudications before the government takes away their property, if it's really not their property. And then you come to the court with a class of people who are property thieves. And you say, we're entitled to 14 steps before the government takes away our property. 1 step or 14 steps, they're still not entitled to the property.
I understand. But I think that here, I guess maybe I'm not meeting the question, but I think here people do have forms of relief available to them. Like those who have been over over 2 years, they might have withholding claims, they might have cancellation claims, adjustment claims, various forms of visas, like, connections to US citizens that could open up different forms of relief. And some of those forms of relief are not cognizable at all in expedited removal, which of course just focuses on the forms of protection. So that's one problem. And I think the other is, if you start with the understanding that people may have forms of relief, some members of this large group that it now applies to, which is everyone in the country, may have forms of relief. The only way you know you have a form of relief is when you're put into removal proceedings, you consult a lawyer, you're able to raise claims as a defensive matter. The only way the government knows there's a form of relief is when it's presented to the immigration judge. All of those turn on the fairness of the procedures themselves. And that's.
But I think as the plaintiff, it was your burden to show for those people who undoubtedly exist that they're not getting the procedure to vindicate their right to stay or their right to not be removed to particular countries. And if they're citizens, they get the habeas after the expedited removal. If they have the asylum claim, they can raise that in a habeas petition. And they also, the government says, are getting the credible fear question. You debate whether that's enough. If they're permanent residents, I think that there's some statute I've found, not statute, regulation 8 CFR 23.5.3B5, and it says they can challenge other lawful grounds, like whether they're a permanent resident. So I get that there are people out there who have a right to stay here. It seems like you haven't shown that for them, the procedures are insufficient.
I understand what you're saying. And, I think that, this is, of course, the preliminary stage of the case. We can always provide more evidence below about this. We think that the notice problem is a glaring enough problem in this case, just as a per se matter, that the stay for that purpose should stay in place. But I understand entirely what you're saying about sort of the need to show the error. I will just say that, one of the things, and this sort of goes back to sort of the uniquenesses of the 1252E3 process, is that because there is this 60-day deadline, you're forced to bring pre-enforcement claims, right? So because after the 60 days might be out of luck. So, and this sort of happened the last time that we had litigated this in 2019 as well. You end up in a position where you have this massive expansion. Hasn't been in place for that long. So a lot of the facts are necessarily have to be, first of all, of course, it's a facial challenge under the statute. Second of all, it's necessarily sort of a little bit relies on inferences from errors made in the past. Because expedited removal was limited to the border, you're not going to see the same types of errors as when it's expanded into the interior this far. So while I take Your Honor's point about the need for us to sort of demonstrate that, I do think sort of like in practice, we are going to sort of have to rely, as we did in the record in the district court, on sort of the past errors that have occurred over the past 20 years. And there's necessarily a certain amount of extrapolation, which might not be involved in others.
Mr.
Sort of,
Christian, I mean, isn't
these
that
cases.
precisely the type of relief that IRERA forecloses, this sort of categorical, class-wide injunctive relief against a particular written policy? I think it's interesting the way you characterize your claim, because it seems to me that that is exactly what Congress contemplated as the type of relief that courts cannot afford in this context.
But I mean, the reason I phrased it that way was because that's the language of 1252E3, which is systemic challenges to the validity, or I'm going to mangle it, but whatever. It's challenges the validity of the system. So, it's looking to systemic relief. It targets writing sort of very similar to sort of like an APA process where you target the writing itself and the policy. And so it is, I think Congress, whatever Congress said in 1252F1 needs to be understood in the sort of context of 1252E3 here. And here, Congress specifically guaranteed, a form of judicial review over new writings as a whole.
A form of judicial review, but not injunctions or restraints.
Yes, I understand. I mean, that goes to the sort of the question of, the nature of the relief, of course, which, I think we've spoken about before. And I mean, our position is that, of course, it's a formalist, position, right? Which is that enjoin, restrain, formally distinct from injunctions, restraining orders because of the in personam effect, et cetera. And Your Honor knows those arguments.
Right.
Yeah.
But so how do you get to a 705 stay in this case? I mean, where the district court has explicitly said, I'm not deciding an APA claim. So there is no APA claim. How do you get an APA stay?
I understand your judge's question, especially from the last colloquy we had on this. And so, and from your writing in the dissent. So I think, and
Why am I wrong in my state dissent?
so, right. I think that, after looking at the case law, I think that it does need to proceed sort of like as under using the APA as a cause of action to get the unique remedy of the APA itself. Here we did sort of specifically request, I don't think this is a pleading problem. I think it was clear.
I don't think it's a pleading problem.
I
think it's a remedial problem for
Right, yeah.
given what the district court did, because if she decided an APA claim, then you might be smack up against Make the Road One.
Right. Mhm.
And so if she says, I'm not deciding an APA claim. And so to me, the only option is she decided an equitable constitutional claim, but then she can't impose an injunction because of F1. So then you have to have an APA stay. It just seems like there are landmines whichever way you go. And I'm not sure what's the best way. Like, what do you think is the best way to avoid the landmines of the APA and IRERA to get the relief that you're seeking?
Yes, I understand. Yeah. So I think it can be construed as an APA claim seeking APA relief. I think there, if I understand the logic correctly, there we run into sort of, I think you identified sort of perhaps a problem with it's committed to agency discretion by law. But I think there, I think, I think the Supreme Court in Lincoln v. Vigil, I think it is, says, and I just pulled the language so I made sure I wouldn't misquote it. It's 508 U.S. 182, 195. It says the APA contemplates, in the absence of a clear expression of contrary congressional intent, that judicial review will be available for colorable constitutional claims. So that's sort of like the language that I was looking at. And it seems to support the idea that, and in Lincoln, the agency action there was found to be committed to agency discretion by law. And yet they still said that about constitutional claims on remand. And
But was the APA, was it APA constitutional claim?
I tried to check that and I wasn't sure about that. So I do want to be clear.
Right?
I agree. If it weren't sort of about, but I was just looking at the language itself. So I can't say that it's clear that it's about the APA, but I do think that it would be, the way that 701A2 is also written, because it says that, it says whatever, this chapter shall not apply except to the extent that agency action is committed to agency discretion by law. And I think that the sort of to the extent language is important, as well as sort of this background principle that you can't, unconstitutional agency action is not a matter of discretion. And so you end up with this question, sort of like this background question of can law commit unconstitutional acts to agency discretion?
But you're not suggesting that designating up to the extent of the statute is unconstitutional.
We are. And that's, I think, clear from.
So there are no procedures under which you could actually,
under
the designation itself, like we are going to apply expedited removal to the full extent of the statute. You're not challenging that on constitutional grounds.
We're challenging it in the absence of constitutionally adequate procedures. And the reason for that is because, under E3, you're guaranteed review over new writings, whatever, and you know that. The question here is sort of like, of course, the designation itself does not on its face sort of specify procedures, but by intent and by force, it brings the rest of the procedures against this new group of people. And in any case, the question is, can this writing be used? Can it facially be used in the to put people into expedited removal in the absence of procedures? For those procedures, of course, you look to see what's in the designation. You look to see what existed before then. You're not challenging those other documents. You're challenging the designation itself.
But so, if we assume, as this panel must, that Make the Road One is correct and that designation decisions are committed to agency discretion by law, then there is no APA cause of action for designation decisions. But even if that's not true, even if you want to suggest there's some kind of constitutional carve out, the district court here explicitly said it was not deciding an APA claim. So what do we do with that?
I would think that and again, I don't have a case for this, so this is just me positing it, it would seem like it's sort of could review it de novo and determine whether there is an APA cause of action. I don't see why, if this court decided that, assuming the court decides that there is APA review over this type of constitutional claim we're bringing, I don't see how it sort of changes the analysis of the district court, given that, the stay from the APA. So it feels like the court could do it de novo in this first instance.
I'm trying to understand your answers and kind of the way that you pled this case. So your complaint, you say that the court has jurisdiction under, you're saying that to the district court, has jurisdiction under 1252E3. So you are citing it as if it is a jurisdiction conferring statute. And then you say the district court also has jurisdiction under 1331. And then in your claims for relief, and I'm looking at let's say the second one, JA 383, you say there's a violation of the Immigration and Nationality Act, and that's 1182A7, the APA 7062, and then you also cite 1252E3. So my first question is, what do you think 1252E3 is? Does it create a cause of action or a claim for relief? Does it confer jurisdiction? Does it do neither? Does it do both? What do you believe this statute does?
I understand. I think at the least, I think it provides jurisdiction. I think that's clear from sort of previous cases in this court. I think as to the question of the cause of action, here, I think we did think we were proceeding sort of, I think, evidence of, the district court's decisions to the contrary. We did sort of think we were proceeding under the APA for the form of relief. So I don't know, and we haven't briefed whether sort of E3 also provides sort of like a separate cause of action in this case. But I understand the question. I just don't really sort of have
Okay,
a fully
so
formed
then my
answer to
next
it.
question is, so your first claim for relief in the complaint is a violation of the due process clause. In under the Fifth Amendment.
Correct.
And so what is your authority for if the court finds a likelihood of success on the merits on that claim, that it can enter a stay pursuant to 705?
So I think, and I don't know whether we cite any cases, but the APA, like putting aside the serious issues that Judge Rao has identified, the APA does provide for review over claims that agency actions are contrary to the Constitution. So it would proceed under sort of the APA as a cause of action with the 705 stay issuing as a result. I think that maybe, and you should correct me if I'm wrong, that your question goes to the 1252F issue in this case, whether 705 stays are available or not, or.
It goes to that, but I guess what I'm trying to get to, and I think it's the same point that Judge Rao was getting at. I don't want to put words in her mouth, but and I guess maybe I'm just too nerdy and technical, but I like to understand what basis there is for any cause of action. If I were a district court judge, which I was at one point, what is the basis of this cause of action? Is it a common law? Is it a statute? What is it? And then how do I know, where do I look to know what relief I can grant, whether it's damages or injunctive relief or a stay, whatever it is? And I guess with respect to this due process challenge, which is claim one, your first claim, your complaint, what is the basis of that cause of action? 1331 or 1252E3 might say there's subject matter jurisdiction in the U.S. District Court for the District of Columbia to bring that claim. But what is the source of that of the cause of action?
Right. So standing here, the way I understand it is that E3 is the way we had framed the stay motion was that, and understood it, was that E3 was providing the jurisdiction. The APA was providing the cause of action and the relief as well in this case. I think, and so maybe that's the short answer, but I don't.
And you think that the language in Lincoln v. Vigil that you referred to is support for the proposition that an APA cause of action can be based on can be the basis of your due process cause of action.
Yes, even though, as Judge Rao pointed out in the first Make the Road decision, specifically the claims, the arbitrary and capricious claim there, and I suppose also substantial evidence type claims would be barred where there is, language indicating that. And that's sort of our argument here.
I think these are all yes or no questions. You have some members who are entitled to be here, correct? Whether it's through asylum or whatever.
We did not identify, Make the Road has a wide variety of members. We did not sort of specifically identify those who are, for example, there are many citizens, many people who are entitled already have asylum. There were those we identified who are in the process of applying for asylum. That makes sense.
So for the members who you identified and who are applying for asylum, is there a declaration from them saying we are entitled to asylum?
I'd have to look back as to exactly what they did. There's two member declarations that were submitted to the district court. I can't remember off the top of my head the specific language in them.
What do you think our court should do if it turns out you have no declarations from members who are entitled to be here?
I think by entitled to be here, do you mean entitled to apply for the legally provided process or already granted relief?
I guess neither. I guess members who the government cannot remove.
Okay, so we don't have any specific declarations from members who say, I have been granted relief, so I cannot be deported. We also don't have declarations from their many members who are citizens or non-citizens who are green card holders, what have you. I don't know whether that changes the analysis, but we can, of course, provide those declarations if it's necessary.
I don't know. I mean, I don't know if it's necessary to my colleagues, and I'm not sure at this point whether we should be making a decision based on new things added to the record.
Right, I understand that.
But fair enough. I think I understand your answer to that. And then have you identified a single alien who has ever been removed as a result of the purportedly deficient procedures who was entitled to stay in the country?
Yes. So this is, I think here again, I believe that in the sort of reports that we've submitted, there are examples. For example, citizens have been erroneously removed through expedited removal.
But no declarations of them.
I believe that we might have declarations. We also have declarations sort of from lawyers who had clients.
And the citizens you're describing who were removed, they were removed as a result of the purportedly deficient procedures?
I mean, yes. Yes, they would have had to be because, citizens shouldn't be removed under expedited removal, should be excluded from it.
I guess though that it wouldn't be a deficient procedure if the government said, we are doing expedited removal for you. The person said, I'm a citizen. The government said, I'll give you every opportunity to show you're a citizen. They provide a passport and a birth certificate showing they're a citizen. And then the government erroneously and unlawfully removes them. That would be an egregious and unlawful removal decision. But that person would not have been denied the proper procedures leading up to that decision. Do you have anyone like that?
I can't recall off the top of my head exactly the specifics of what happened in the cases.
Can I ask you also about Make the Roads 705 arguments? So there seemed to be in the briefing before us leaning into the idea that what the district court did is postpone the effective date of this. Just wondering how that's possible since these designation decisions take effect immediately and you can't postpone an effective date after an effective date has passed. So I'm just wondering why, it's just completely frivolous argument.
Well, I think that there's multiple district courts in this district that have entered 705 stays or postponements after.
That's the difference between a stay and postponing the effective date. Postponing the effective date, how can you, just by the plain meaning of those words, how can you postpone a date that has already passed?
Right. It doesn't, and I don't have the statute in front of me, unfortunately, but I believe there's also sort of other language in there of take any other such process necessary.
Right, but
so perhaps that provides.
That's part of the stay language, but I Make the Roads argument. So, I guess this is relevant to the idea of whether it's possible to issue universal relief. And I Make the Road as arguing that because you can postpone the effective date as to everyone, that's what happened here, and that justifies universal relief.
That's correct.
But I don't understand how you can postpone the effective date of something where the date has passed.
Right, but doesn't the same, whether it's postponement or whether it's a stay, in either case, it's operating against the agency writing itself. So I think that's sort of the formal answer to the question, which is that
Well, it seems that Make the Road believes there's some distinction between postponing the effective date and what is effectively a stay with respect to universal relief.
Okay, I understand the question now. So I don't know whether, because I think the real question is whether sort of how 705 operates as a whole. And I think here it's indicating that the form of relief specifically authorized by 705, no matter what we call it, is acting against the agency action in the same manner as vacator does, sort of against the document and
Okay.
not in personam.
Okay, well, okay, so then I'll just put aside the postpone the effective date, which I don't see how that could even apply in this context. But then why do the traditional equitable factors not apply under 705, which specifically incorporates almost all the words that we think of in traditional equity practice, right? It has to be, it can, on such conditions as may be required and to the extent necessary to prevent irreparable injury, right? And may issue all necessary and appropriate process. So, I mean, all of those terms, right? Necessary and appropriate, it has to be irreparable on such conditions as may be required. I mean, these are all words that explicitly incorporate traditional equitable principles. And so if that's true, and I'm not sure how I could argue against that, but I mean, those words all invoke traditional equity practice, then why do the principles of CASA not apply?
I understand. I mean, I think there the question is, you can read that same language to sort of to refer to sort of those tools, whether in equity or not, that look to the propriety of preliminary relief in a case. So, of course, and this is possibly the reason that district courts have used sort of the traditional Winters test in adjudicating these, which is, of course, the difference between sort of a 706 vacator and sort of 705 preliminary stays or postponement is that, you're making a decision before, the full judicial process has completed. And so there is necessarily a certain amount of, prognostication about the likelihood of merits, also, consideration of sort of like the necessity of moving more quickly.
After CASA, if you're going to award universal relief, you have to justify it.
But
They're traditional equitable principles.
But I think this goes back to the formal difference between, the operation of sort of, equitable injunctions, for example, and AP relief under the APA, whether 706 and 705, which is that, in one case, they're operating in personam, for example, and the other, they're operating against the document itself, which is a formal
I don't think
matter.
that's true because in 705, postpone the effective date of an agency action. Maybe postpone the effective date of the agency action operates on the agency action, but you can't get that relief here because the effective date was an immediately effective designation. So you're under to preserve status or rights pending conclusion of the review proceedings. So status or rights is not agency action. It is you're preserving under 705 the status or rights of the party in the review proceedings. So to preserve that is what the 705 stay is doing in this case. And how does that give you universal relief?
Right. I guess there's two. But I think that, so for example, in Niken, when it's talking about stays, there it's the same, it's a stay as opposed to postponement. And it's still operating against in the Ken,
Well,
the
that's
court
a stay of
understood
a
it.
judicial proceeding. It's not a stay of an executive action under 705 of the APA.
That's correct. It's a different source of authority. But I think that in the end, if I recall correctly, Niken is about an order of removal. So it's still sort of an
That's an
administrative order.
individual adjudication. So it's not universal relief. It's not a universal stay. I don't think Niken tells you what this
I correct
means.
that I agree with you that it doesn't sort of like it, is dealing with the individual relief as opposed to sort of like
How do you
relief.
get
for a group.
universal relief under 705? Postpone status or rights pending conclusion of the review proceedings, which
Right.
are review proceedings of a particular plaintiff, or I guess in your case, a group of plaintiffs.
Right. I think, and I'm afraid I might be repeating myself here, but I think it's because it's a form of relief that operates against the underlying authority, like a stay.
Why does it operate against, how are the status or rights
You're entering
are-
that to protect status or rights.
of a person
Right. But
in a review proceeding?
yes, but I think that
So how does that include the agency action? And in fact, I think it's indicative, right, that you can postpone the effective date of an agency action. And by contrast, you can preserve the status or rights pending conclusion of the review proceedings, which on the one hand, you can postpone agency action, operates maybe against the whole agency action, or at least arguably. But I don't know. I mean, the contrast suggests, no, you preserve status or rights of parties, not agency action.
I take your honor's point on this, and there might, the distinction between the two, like perhaps forms of authority. I do think that overall 705 still should be read sort of structurally parallel with
but you're not.
706.
But why? Why based on the text or the history, or you've got to give every time I give you a specific word, you say, okay, but generally we should get it. I mean,
Right.
You have to be able to either link to traditional equitable practice, to the text of the statute, to something in law, presumably.
And, other than what we have in the briefs, and I think also sort of the explanation of it in the stay decision, I'm not sure I have anything to point you to at this moment that would sort of answer fully the questions that you're raising. But I think
No, I'm trying to understand, are you agreeing that you can't postpone something once for purposes of 705, you can't postpone the effective date of something if it's already been.
I'm not sure whether
implemented?
that's
Are
correct.
you agreeing with that construct? I'm just trying to understand.
No, I'm not, but I think it's partially just out of not lack of preparedness for this question. I don't, it seems like you should be able to, but I'm not sure how exactly sort of it's been interpreted in this manner.
We
I
have
do
case
think
law
that
on the
I'm trying
circuit
to-
saying you can't do that.
Okay.
I didn't catch that.
We do have cases saying that you can't do that.
But I guess I would just point to one other thing outside of the APA in this case, which is, let's assume that, as opposed to postponement, a stay is only party specific. I do think that here you end up with you should read it in combination with 1252 E3, which is that, E3 is providing, again, for sort of like a single judicial action against any given agency writing. And it makes sense then, for the same reasons why vacator should be available under E3 and why E3 relief should operate against the writing itself. The same should be true in sort of any sort of preliminary stay sort of in an E3 case. So even if sort of a stay under 705 is, incorporating, all equitable principles or party specific relief in the context of a 1252 E3 case, I think, reading it consistent with 706 and sort of full relief against the writing during the interim of the judicial proceeding makes perfect sense. Because the other, no other parties are going to be able to challenge it. There's no other sort of like need for percolation. And I think this, reading the APA consistent with the specific review provisions that Congress created seems entirely sensible.
Any other questions? All right, thank you.
Thank you, Your Honors.
Mr. Ensign, we'll give you 3 minutes for rebuttal.
Thank you, Your Honors. I appreciate the indulgence. Just very quick, wanted to answer one of Judge Walker's questions. You would ask that if people are given notice that they're in expedited removal, that is at JA 355 of the record. The form itself is called Notice and Order of Expedited Removal that's provided. It also includes specifically the charges that people are asserted to be removable under. And so we do think that the notice of expedited removal, that they are being placed in expedited removal is provided, and that is in the record. And then if I might, 4 quick points. One, I didn't hear any evidence that a denial of notice or opportunity to present evidence has ever caused anyone injury. So we think that there is a complete absence of Article 3 standing to bring that aspect of their challenge. And that's essentially the only thing that the state panel, focused on. So I think jurisdiction is lacking there. I didn't hear any denial that that how long someone has been continuously present in the country is an affirmative defense. And we've cited to the Second Circuit case that recognizes that due process doesn't require the notice that that an affirmative defense might be available to people. Third, I didn't hear any dispute whatsoever that the rule of Thursighian and Nishimura would apply to those who have been lawfully paroled into the country. And no matter how long they've been here, and indeed in the Kaplan case, the alien had been here for more than 8 years. And so the only question is, do people who have unlawfully and clandestinely entered our country, are they entitled to better treatment than those who have been lawfully presented themselves at ports of entry and were paroled into the country? And I think it's both legally incoherent and morally perverse that they would have acquired more rights by illegally entering the country than those who lawfully were paroled into the country. And finally, as Judge Walker was pointing out, there is no constitutional interest in process itself. The Supreme Court held as much in the Olem case. Indeed, the state panel here was unanimous that the procedures used to adjudicate fear claims are constitutionally sufficient. That is at least the vast majority of all aliens. And I don't believe plaintiffs have specifically pointed to deficiencies that have affected anyone else specifically that they lost a claim they might otherwise have. So there's no standing to seek such relief.
You pointed to this JA 355. I just want to confirm notice and order of expedited removal, determination of admissibility. They get to see this before, after they see this, they could, according to the ICE guidance, say to the government, I've been here longer than 2 years. I'm not in, so I shouldn't be subjected to expedited removal. And then the government would say, we give you a brief but reasonable opportunity to show that you've been here longer than 2 years. That's the chronology of how this would work, correct?
That's certainly my understanding, and that's what I believe is both the 2019 and 2025 guidance provide.
Thanks for
But that's not in the record before the district court.
It's correct that the 2025 guidance we've asked you to take judicial notice of. The 2019 guidance is not in the district court record. It was cited to this court in the state briefing.
I mean, we're not supposed to be finding fact up here.
As a general matter, no, but we've explained why taking judicial notice would be appropriate here, and we don't believe that any of the plaintiffs have provided any reason why taking judicial notice would be inappropriate. It is, in fact, the official policy of the United States. There's no dispute as to its authenticity. It is, in fact, official government policy. Federal courts take judicial notice of that all the time.
We can take judicial notice of a policy. We can't take judicial notice of whether the government follows the policy.
That's certainly correct, Your Honor, but I would also then point to, if we're going to go by what there are deficiencies in the record, there's a complete absence of proof that the alleged constitutional deficiencies have ever caused any injury to any actual person. So if we're going to go by what the absence of the record shows, what the correct outcome here is, plaintiffs lack Article 3 standing to challenge the relevant procedures, and thus no relief should have been entered on such claims.
All right, thank you. The case is submitted.
Thank you, Your Honors.
Case number 25-7063. Gina Latture, appellant versus Priority Life Care LLC. Mr. Branch for the appellant, Mr. Murphy for the appellant.
Morning, may it please the court. It's a senior moment when you forget that you have your glasses in your hands and you're looking for them. Good morning. My name is David Branch. I represent the appellant. This is an appeal from the district court's grant of summary judgment and dismissal of claims under Title VII, Civil Rights Act of 1964, and 2 common law claims. There are essentially 3 arguments that are going to be made this morning in support of this appeal. The first is that the district court ignored direct evidence of racial discrimination and racial bias. Then the district court improperly made credibility findings in reaching its decision. And finally, the district court imposed pleadings and proof standards beyond those required by the law. Let's start, if I may, with the hostile work environment claim. Excuse me.
Do you want some water?
Yes.
Here.
Oh, my God. The district court adopted my friend and colleague's arguments on the hostile work environment claim, essentially accepting the claim, the appellee's argument that the allegations made were not severe and pervasive. And for 2 reasons, the court concluded that some of the comments were not racial and other comments were not directed toward the appellant. As I count through the record, there are at least 7 comments that are either racial or have racial implications. Jernigan, who was the supervisor, telling my client that a co-worker was an ignorant Black bitch. And I note that even appellees were very concerned about even using that word, or this phrase. They resorted to using an acronym, IBB. But that's one comment. And then the supervisor also said, at least I didn't call her the N-word. Someone else in the workplace referring to Blacks as ghetto Blacks and hood rats. And as the court is aware of the facts, my client was a director of marketing for a building that was being filled by residents, or they were attempting to get residents to move into this building in Southeast DC. So that was the 3rd comment, or 4th comment, hood rats. Another supervisor, in fact, the person who was responsible for the termination, referring to African-American men as a pack of animals and monkeys. Another person in the workplace reported that an African-American female that she encountered had a bad smell, and she smelled like the V word, or slang for the V word. And then another employee stating, what's wrong with these people? They live in the ghetto. Don't they want better? Don't they want anything better than living in the ghetto? So there's direct evidence of discrimination, and this aligns with this court's decision on the Yissi Etta v. Fannie Mae. The district court seemed to believe, or took the position, that because these comments were not directly tied to an employment action, that these were actually stray comments. And this is maybe one of the most egregious cases of discrimination, short of calling someone the N-word. They did everything but calling this person the N-word. And all of it was done in her presence. And this is the work environment that she's working in. And she's an African-American director working in this position. So we believe the district court erred in concluding that these comments were not severe or pervasive. These are comments that were made over a period of 6 months. She began employment in January 2021, terminated in August of 2021. So that's the first point on the hostile work environment claim. For the disparate treatment claim, we believe that claim, the district court erred there as well. specifically with the disparate treatment, she establishes the prima facie case. And the law in this circuit is that once someone establishes the prima facie case, she's African-American female, I think she was 62 years old at the time. She was terminated from her position, placed on a PIP first and terminated. And she met all the elements of a prima facie case. So the next step just becomes whether there's sufficient evidence in the record that a jury.
Just with the hostile work environment claim, I don't think that this case was cited in the briefing, but there's a case from our circuit, Baloch v. I'm not sure I'm pronouncing it right. It's Baloch v. Kempthorne, where we affirm summary judgment against the plaintiff in a hostile work environment case. And in part, we relied on the fact that comments weren't directed at the plaintiff. The racial comments weren't directed at the plaintiff. Can you point me to any case where racial comments were not directed at or about the plaintiff, and yet we have found that to be sufficient for a hostile work environment?
Your Honor, I think the Baloch case can be distinguished by the work environment that's created here. I understand the court's position in terms of citing to a case where, you know, the comments aren't made directly to the person. But if you look at the volume of the comments here, we had, as I just cited, 7 instances of comments made directly to her in the work environment where she essentially says, your colleague is an ignorant black bitch, or calling the colleague an ignorant black bitch. All of the other racial comments, there's nothing that compares to the facts in this case in Baloch.
Okay, but as far as any case where the statements weren't made about the plaintiff, do you have any precedent where we found hostile work environment under those circumstances?
Your Honor, I have not, but that can't be the sole basis for a hostile work environment, that someone has to make comments directly about the plaintiff, particularly when you're dealing with a very short period of time. You have these comments essentially on a day-to-day basis where this supervisor is making disparaging comments about African Americans. Everyone in the office apparently is making disparaging comments about African Americans, insulting the intelligence of an African American coworker. I don't have a case to cite that, but Your Honor, if that needs to be expanded, I think this should be the case where the court considers expanding that. If someone creates an overall hostile work environment, I don't know what else you can describe this as. I don't know many places where you have to go to work and sit down and your supervisor says your coworker is an ignorant black bitch, or all the other racial comments that were just mentioned here. So that's for the hostile work environment. For the disparate treatment claim, once again, it begins with once the prima facie case is established, the question is really whether there are facts in this case that a jury could conclude that this decision was racially motivated, or appears racial, but because of the protected class. And we have this based on, first, the hostile work environment that's created where the managers are essentially saying, this is how I feel about your African-American colleagues, plus all of the African-American people that we're servicing or that we're offering services to, that this is the ghetto and, hood rats, all of these other comments. So it begins there with this foundation. This is the claim, this is racial discrimination, and then it goes from there to.
But the way we analyze this is we look at, okay, you've made your prima facie case, but we don't really care about that anymore once a legitimate non-discriminatory reason is proffered for the employment action. Here it was a termination.
Yeah.
And they said unprofessionalism and insubordination.
And
So then the question just becomes, is there sufficient evidence to send it to a jury that that was pretext? And my reading of the summary judgment opinion, and I took a look at the statement of undisputed fact and the response of the plaintiff to that, I didn't see where there was a dispute that the statements that they say were insubordinate and unprofessional around the time of August 9th. I didn't see anything in Ms. Latoure's affidavit or in the statement that said that she did not make those comments.
Your Honor, we provided an affidavit with her detailed statement of exactly what happened on that occasion and all the other.
I'm telling you, I read it and I looked at it, and specifically around, this is at J 567 and 568, it's paragraphs 49 to 53, 54. And I don't see where she ever says, I didn't say any of those things that they said that I said.
Okay, so Your Honor, well, first, I understand the court's question in the context. Let me just place this in the context. First, the comment about black bitches made in June of 2021 by Jernigan. In July, Miss Latture suddenly placed on a performance improvement plan. She was supposed to meet every week. The employer doesn't comply with its obligations. And then in September, she is being terminated. So we go from, there's a shifting articulation, and that actually supports a claim of discrimination, because first there's a claim that you're going to be terminated because of your.
The reason given for the termination on or about August 12th is insubordinate and unprofessional conduct. And it was based on this exchange that happened with two different supervisors on or about August the 9th. And what I'm saying to you is, for an at-will employee, that's sufficient grounds for termination. And what I'm saying to you is, I don't see in the record where Ms. Latture said, I never said or did the things that they said that I did on August the 9th that were unprofessional or insubordinate. Did I miss that? And where, if so, where is it?
Your Honor, I will check in the record, because I know that she specifically did not agree with this characterization of being unprofessional or insubordinate.
I know that you submitted a counter statement of disputed fact that denied that paragraph, but it didn't cite anything in support of that denial, which our local rules require and the federal rules require, precisely because at summary judgment, we are trying to determine whether there is evidence in dispute of a fact. And it can't just be that you file a pleading that says, oh, we dispute that fact. You got to point to something in the record. And there was nothing identified in the record. That's at JA 544.
Your Honor,
It's denied, and it says the accusations are false and were manufactured to cause plaintiff's determination. No cite.
okay, Your Honor,
There is a cite for the next thing that is denied. So that jumps out at me when I
Okay.
don't see a cite, and then when I read her declaration and I don't see a denial.
all right, Your Honor, then I will check the record. What I was going to say is, yes, that's the reason that they gave for the termination, and she denies it. But before it was an allegation of poor performance. So in the course of 1 month, we go from an allegation of poor performance, which you're not selling these units in Southeast DC, where people have to come up with thousands of dollars in money to move in, to now we're terminating you because of, allegedly because of, conduct that happens at this.
Things aren't mutually exclusive. I mean, you can have concerns about an employee's performance and put them on a performance improvement plan.
But
And then later, there's an outburst that's unprofessional and you decide that you're just going to fire them based on that.
there was no unprofessional outburst.
Well,
And
that's what I'm getting at. They said that there was, and there's nothing in her declaration that says I didn't do that.
okay. So, Your Honor, what I was saying is that there was essentially a shift. She's in this position for 6 months without any of these allegations, and suddenly she makes an allegation against her supervisor, or supervisor makes this racist comment, and then she's placed on a PIP, and she's going, based on these subjective statements of what happened in this meeting, a determination is made that she should be terminated. And then when that decision is made, the person who makes the decision is soliciting comments from other folks to tell me, give me information to help me support this decision to terminate Ms. Latture. All of that's in the record. That's not disputed. If you present that to a jury could very easily find that this is.
What inference that's nefarious do you get from the deciding official saying, okay, what she says sounds like grounds for termination. Write down the statements, but I'm going to terminate her. There's nothing that says that the deciding official has to wait until they get the written statements to take action.
Okay, so okay. What is the question, Your Honor? I didn't get that.
I mean, you're saying that all of what's in the record would cause a reasonable jury to believe that this was all manufactured.
Yeah.
And I'm saying, why? They said they told the deciding official what happened. The deciding official said, give me statements. And the deciding official maybe didn't even wait for the statements. They heard the accounts of what happened, and then they took action.
But Garrido is one of the folks who made some of the racial statements herself.
Well, you might have a shooting match if your client had said, I never said those things on August the 9th.
She
Your
denied.
client didn't.
She denied that. She denied the statement, Your Honor.
Well, I don't see that in the record.
Okay.
So
I can.
does anyone have any other questions?
One quick fact clarification on the retaliation point. Ms. Latture objected to Jernigan's comment. It was Gerardo who made the decision to fire Latture, and Gerardo did not know that Latture had objected to Jernigan's comment. Correct?
Yes, Your Honor, but 2 points. Jernigan, first, the incident with Jernigan, we just discussed that, where Jernigan made the comments. Jernigan feeds the narrative to Gerardo on why Ms. Latture should be terminated. So we cite to the cat's paw, theory that, okay, you have even if she was non-discriminating, Gerardo, which she was not because she had made racial comments herself, but Jernigan definitely has an issue with the plaintiff, and she knows that the plaintiff is going to likely file some type of claim against her, and she moves forward. She's already made these racial comments. She moves forward with making comments to Gerardo to cause her termination. So under this,
I understand that
cat's law.
Did you have, I think that was that both of your points, or?
Yes.
Okay.
And if I just may, so that's the same is true for the retaliation claim, as well as the wrongful termination claim, where she alleged in her complaint that there was an effort to move residents in without the correct medical documentation, and she was terminated because of that.
All right, thank you. We'll give you a couple minutes on the budget.
Good morning, Your Honors, and may it please the court. My name is Jim Murphy. I represent Priority Life Care, the appellee in this case. Quick background, I'm going to make 5 points and then answer any questions you may have. Before that, though, just for background, Priority Life Care is a company based in Indiana and were contracted in, don't typically do business here in the District of Columbia, but we're contracted in here to manage Livingston Place, the assisted living facility in Southeast DC that was open where all the relevant events occurred. Excuse me. I want to focus on the termination decision, if I could. The analysis we believe is guided by this court's decision in the Brady case, wherein the focus really ought to be on whether or not the decision maker, Ms. Gerardo, had an honest and reasonable belief that the plaintiff appellant had been subordinate and unprofessional. The honest and reasonable belief in this case was based on not only her own experience on these calls directly interacting with the appellant, but also from an email and a series of events that preceded the email exchange that is in the record. Okay. And this is all laid out, and it sounds like you're familiar with it, Your Honors, but there are 3 emails on the 11th that reflect the decision that was made here. The 8:45 a.m. from Ms. Jernigan, alerting the two people at corporate as to the behavior on a group call and some other issues that preceded it with the appellant. There's the 9:06 email where Ms. Gerardo responds, and the 9:09 email where she announces, "I have made this decision." She makes a decision based upon the information she got from that 8:45 a.m. email, as well as her own experience. Okay, and we'd submit that she had an honest and reasonable belief that conduct had occurred based on particularly the loud and confrontational behavior that was observed on these calls, yelling and talking over her managers. And all this is laid out in a series of documents in the record, JA 442, JA 446, JA 448, JA 450, and JA 435. The other thing I would add here that is that I think should be taken into account is that a lot of the friction had to do with the fact that the appellant had not been adopting the various marketing protocols that the company required for all of its sales and marketing people at the facilities to utilize. And she had various reasons for not doing it, but one of the, and that's in the record, but one of the things that she made very clear was that I don't have time for it. It's a waste of time. In her own declaration, she says very clearly that she disagreed with these things, with these marketing protocols. They were ineffective, and she felt strongly that they should have been voided. These protocols were things that the corporate office used to be able to monitor the extent and progress of sales locally. Okay, and Ms. Latture resisted adopting them, and that was in the documentation that was included among those things shared in the 8:45 a.m. email. Sorry.
On the hostile workplace issue, the comments were pretty awful. Can you just address that issue?
Sure. Well, we agree with the district court's opinion that it did not reach the severe and pervasive level. There were 2 things going on here, I think. Importantly, I would mention with respect to the termination, I'll tie them together, I promise. But with respect to the termination decision, okay, none of these comments were. I know one was said in front of, or the plaintiff overheard them, but none of those comments were directed at the plaintiff, at her termination, at her employment, at her performance. Okay, and the same thing is true with the statement that Ms. Jernigan supposedly made to Ashley Lawrence. Okay, none of them were directed at the plaintiff herself, so therefore none of them have a connection to the ultimate termination decision. With respect to those comments, each of them is denied. The plaintiff's counsel took depositions, and each of those individual and individuals denied having made those statements.
But that summary judgment, the district court can't make
No, right.
credibility finding
No.
that they didn't happen. We have to assume,
Right.
taking everything in the light most favorable to the appellant, that they happened. And so based on that, should we send that claim to a jury?
Right.
And so why isn't it a hostile work environment to hear racist comments repeatedly throughout the course of your employment, especially if they're directed at your race?
And I was just trying to address your question, Judge Walker, tell me about that, the hostile work. So I understand they're in dispute. There were some of these statements that were, the council talks about you people, okay, or these people, those people. Those comments were made, if they were made, they were directed at the people in the community that the Priority Life Care came to serve. It was a low-income housing facility. It was put where it was put in Ward 8 to be able to serve people in Ward 7 and Ward 8. So there, to the extent that there was a reference to why won't these people come here? Why do they want to live outside of here? Why don't they come and live with us here in this facility? It was those people, these people. That's what it was referring to. It wasn't supposed to be aligned to race.
Why, if we take everything in the light most favorable to the plaintiff and give the plaintiff the benefit of all inferences, which is what we're supposed to do at summary judgment, why isn't it a fair inference that there was a racial aspect of it? Why couldn't a reasonable jury say, I know what they meant by you people, and that was racial? Why wouldn't that be a fair inference, a reasonable inference that a jury could make? I know you would argue that they shouldn't.
Right. Well,
As a matter of law, we would say you can't make that inference.
I would say contextually in this case, that's not an inference that's supported.
And suppose we disagree with you, and we think that all of these statements, there's a reasonable inference that they are racial.
Well, among other things, they were not. The statement, one was made, allegedly made in the presence of the plaintiff, of course. The others were not made knowing that she could overhear or knowing that she was listening. She overheard them, she has said. She wasn't sure if the speakers knew she could hear. Okay. And whether or not the statements, the comments in a hostile work environment case are directed at the plaintiff is critical to determining whether or not there was, an intentional, intentional conduct here. The other piece I would mention is that the company did have a harassment policy, a hostile work environment policy, and it wasn't utilized.
As your friend on the other side says, it can't be the case that there can never be a hostile work environment unless a comment is directed specifically at the plaintiff. That would be a strange rule.
Well, under the precedent, I believe that we've cited several of the cases. We believe our case is analogous to those where the high bar for a hostile work environment here wasn't met in its totality.
Well, let's take whatever the worst comment was. We don't have to repeat it, but just whatever you think is the worst comment. Mm-hmm. Imagine that comment was made once a week for a year. Would that be a hostile work environment, not directed at the plaintiff, but made once a week?
There would be, I'm stuck. I'm trying to imagine the situation in which it is repeated without the plaintiff, without the person knowing the plaintiff was present, or without knowing the plaintiff was there to hear it.
Well, just imagine that the plaintiff could hear it. It wasn't directed to the plaintiff, but the plaintiff could hear it.
I think if you're going to hold the company liable, there has to be some kind of intentionality to it. And if the statement is made without knowing that the individual is hearing it,
well, imagine
there's no intentionality.
They knew the plaintiff could hear it. It wasn't directed to the plaintiff, but they knew the plaintiff could hear it.
And knowing it could be. I can't say it could never be.
I think that's the right answer.
A last couple of points. I see I'm just a little bit over my time. But with respect to, we don't believe there's direct evidence of discrimination. We believe this is a stray remarks case. And in this case, and under Morris McCarthy and other precedent within the circuit, the stray remarks here do not ultimately support pretext because there's no connection between those remarks and the actual adverse action at issue. Also, I should mention with respect to the retaliation claim, the alleged protected activity occurred not in June, but at some point during the winter months between January and March, because the plaintiff testified at her deposition that it occurred when they were in the off-site location, which was during those months and before they moved into the assisted living facility in April 1. So that was something I wanted to point out. I don't believe the cat's paw theory applies here for one particular reason. With respect to the 8:25 a.m. email, okay, the Supreme Court was very clear in the Staub decision that the supervisor who's supposedly providing the tainted bias on the decision, that person must be acting with the intent to influence the adverse action. And in this case, and that's the general rule that was enunciated by the Supreme Court in the Staub case. And we have a couple of court decisions outside of this jurisdiction, which we can provide, which uphold that application to say if the individual who made the statement, the supervisor, didn't in fact intend to influence, just know the termination decision or whatever was being made, then in that case, Staub would not apply. And that's the case with the 8:25 a.m. email. With the latter written statements that were provided, they came in after the termination decision was made. So therefore, they can't ultimately have proximate cause on the termination decision. Lastly, with respect to ultimate bias in the termination decision, in the record, as you know, we indicated that the company, by 18 days after plaintiff was terminated, hired her replacement, Brandon Webb, who is also of the same race. And under Murray v. Gilmore, 406 F. 3rd 708, that fact cuts strongly against any inference of discriminatory motive in the termination decision. Lastly, one more point on the retaliation claim. I'm sorry.
You're just over your time.
Quickly.
On the retaliation claim, plaintiff under Minter v. DC Circuit 2015, the authority in the circuit is that plaintiff would need to show more than temporal proximity and knowledge here. And in this case, she had neither. We would submit.
All right. Thank you.
That's all we have.
All right, Mr. Branch, you're out of time, but we'll give you 2 minutes.
Thank you, Your Honor. Your Honor, I think the final point that was raised that the appellee hired an African-American male to work in Southeast DC in a high crime area, that actually undercuts their argument of selling units to African-Americans. They had previously hired Miss Latture for this position. It comes as no surprise that they would specifically look for an African-American to work in this area, given the facts of this case. And so I think what's been suggested by defense counsel just does not help their position at all. It supports the position. The cat's paw theory applies specifically to Jernigan. She made the comment specifically to cause the termination of the appellant. And once again, on the racial comments, it's clear, but at least we believe a jury could easily find that the employer created a hostile work environment based on the severity, the pervasiveness, and the egregious nature of the racial comments, the ignorant black bitch comment. That comment alone, according to the Assisi Etal case from the Court of Appeals, where the court says, where I think the gentleman was told, you're doing fine for a Black man, or you're good, you're fortunate to be in this position as a Black male. A comment like that alone can alter or change a work environment. That's what happened with this comment about your colleague being an ignorant Black bitch. Thank you.
All right, thank you. We'll take the case under.
This honorable court now stands adjourned from the Thursday, Sunday, 1:30 p.m.